What's his name? Felix Asotie. It's not a matter we are
on data protection for workers. I think you have that on the screen. So we'll be looking at that vis-a-vis the Nigeria Data Protection Regulation. Being one of the draftsmen, and as a matter of fact, with all modesty, the lead draftsman of the NDPR, or the reform of the 2017 guideline, we did some things that would favor all categories of citizens, whether they are in formal employment or otherwise. I think I can proceed with the slides. Hello? So the first thing that we have, introduction to data protection, we ask, what is personal data protection? What is personal data protection? Personal data protection consists in the application of rights to privacy principles and peremptory norms of international law for the purpose of safeguarding the socio-economic integrity of lives and livelihoods. At this moment, we can pause to ask why peremptory norms of international law, and why do we have to bring those into the application of the data protection. As you are aware, Nigeria Data Protection Regulation, or any data protection regulation for that matter, is a of rights to privacy. That is, it flows from fundamental rights. And as of this moment, hello? Hello?
proceed, please.
We can hear you.
Okay, you can hear me. So as of this moment, the human rights regulations, or the human rights instruments, the fundamental rights particularly, are part of the peremptory norms of international law. So if you have any practice direction, as I would like to call it, the NDPR, for instance, you could call it a practice direction on the enforcement of right to privacy. So to that extent, it comes under the peremptory norms by which you cannot have any form of derogation. So as far as that is concerned, I think we are covered on the aspects of what is personal data protection. Now, the Nigerian Data Protection Regulation is a response to the EU General Data Protection Regulation, which came into force on the 25th of May 2018. And by virtue of Article 41 of that GDPR, any nation that is outside the EU jurisdiction will have to comply with what the EU draftsmen, or the parliament in the EU, calls adequacy level. Adequacy level in the sense that if you are not part of the jurisdiction of the EU GDPR, then your country must have certain level of protection for the processing of personal data, so as to enable the free flow of trade between that country and the EU countries. But at the time the EU GDPR came into force, Nigeria had no regulation that could meet the adequacy level. So we came in to do the NDPR so that Nigeria can meet the adequacy level under the NDPR. Now, the objectives of the NDPR are to safeguard the rights of natural persons to data privacy, to foster safe conduct for transactions involving the exchange of personal data, to prevent manipulation of personal data, to ensure that Nigerian businesses remain competitive in international trade through the safeguards afforded by a just and equitable legal regulatory framework on data protection, which is in tune with global best practices. You see Article 1 of the NDPR for that. Now, you may want to ask the question, what is personal data itself? Various things may be regarded as personal data. For instance, your name, the color, your ethnic group, your tribal origin, your political opinion or whatever opinion. For instance, you're on Facebook and Facebook is asking you what is on your mind. Those things constitute personal data. Anything that, any information that you could be identified by constitutes personal data. So what is the scope of the regulation? This regulation applies to all transactions intended for the processing of personal data, notwithstanding is that we may have situations whereby your employee can say that they are processing data just with paper and not electronically. But the scope of NDPR is to cover the entire field, if you will, cover the entire scenario of data protection. So employers cannot say, for instance, we don't even have computer in our office. We have a paper, but of course, at the end of the day, whatever they have in paper, perhaps they will do photocopies, perhaps they will take numbers from the paper and send phone calls or make phone calls. And ultimately, there is a relationship between the paperwork and some form of electronic data processing. And finally, this regulation applies to all Nigerians, and they apply only to natural persons. And of course, we again said that this regulation shall not operate to deny Nigeria or any natural person the privacy rights he is entitled to under the law or regulation in any manner whatsoever. So in the course of our discussion, we shall be looking at ILO as it relates to the scope of this regulation. Now, the ILO code for data protection, which by necessary implication has been imported or could be imported into our own practice, has certain principles, just like the NDPR and the GDPR. First, the principles that data processing must comply with are lawfulness, fairness, and transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity, and confidentiality. So I briefly explained what these principles are. And the first one, lawfulness, fairness, and transparency, that when you are processing data, it must be for a lawful purpose. Any processing of data, whether they are your employees or not, and they are not lawful, is null and void. And then lawfulness means compliance with Nigeria Data Protection Regulation or any other regulation in force for your privacy. If any data processing is taking place and is not in compliance with any regulation, such can be regarded as, unlawful. And then there is fairness and transparency that speaks for itself. Then purpose limitation. Now, this is a gray area in data processing. It's a gray area in data processing in the sense that a lot of people collect data. For instance, they collect the data of their employees, and then maybe an organization comes along the way and says they are offering certain services which which goes beyond the purpose for the collection of the data in the first place, then any processing of data beyond the purpose or lawful purpose, then it's in violation of the employee's rights under the data protection regulation. Then data minimization. Now, it is recognized that we do not have to collect data of every form of data. For instance, you are employing somebody and you are asking for his, his religious beliefs, whether it's Hindu or his sexual orientation, as the case may be. Although in Nigeria, I think no law could, criminalize you or come after you if you are asking for sexual orientation. But internationally, on the best practice, that is not fair and that is not required. So data minimization, you just ask for what is required. So as labor lawyer, employment and labor lawyers, and when we review data privacy policy of our clients, we have to look at the kind of data that they collect from their employees to know that they are lawful, they are limited to the purpose, and of course, they minimize data being collected. Then accuracy. For instance, somebody is employed as a single. Down the line is married, but the record she has or he has with the employer remains that did not change his status. That also is not accurate. So as soon as your employer or as soon as your client says that, as soon as your employee says that he has changed his status, maybe whatever it is, even his address or his telephone or what have you, then you are duty bound under the NDPR to change that. Then storage limitation. We have people that continue to keep data, personal data of people that they don't even need anymore beyond the time. For instance, maybe it's a casual worker and he's gone and you are still keeping all manner of records. The only thing that is that is allowed, maybe for security reasons, then the way by which you collect the data and store the data is different from the way that you store the data of people that you have that are still in your employment. Hello. Please, I need to know whether
I can hear you.
All right, very good. Now, storage, we have spoken about storage limitation, then integrity and confidentiality. Every data given to you, given to an employer must be kept safely. And that means when we talk about integrity and confidentiality, we talk about the software as well as the hardware that will not compromise or will not allow a compromise of the data given to an employee or given to an employer. So NDPR in the context of employment, as we have stated under our introduction, we said that NDPR does not categorize data subjects, whether they are employed or not. The reason is that NDPR is a form of practice direction in respect of enforcement of the constitutional right to privacy. The most critical condition that varies the privacy rights of one data subject to the other is the concept of consent. Now, earlier on as well, we spoke about ILO code of practice. Well, I can see a question. Please, let's bring that up as soon as I'm done with a rundown of the slide. ILO Code of Practice on Protection of Workers' Personal Data. As we stated earlier, that the NDPR itself contemplates that there could be instruments that protects the data, the personal data of, of employees or natural persons anywhere. So by Article 2(9) of the NDPR, we have, notwithstanding anything contrary to the regulation, the privacy rights of a data subject shall be interpreted for the purpose of advancing and never for the purpose of restricting the safeguards data subjects is entitled to under any data protection instrument made in furtherance of fundamental rights and the Nigerian laws. By that, we can import the ILO Code of Practice on Protection of Workers' Personal Data. So in advising your clients, it may be that under the NDPR, particularly, you do not have sections pertaining specifically to employers and employees. However, you will do well to call the attention of your client to this particular application, to this particular article. And of course, this, as we stated earlier, the NDPR itself is flows from private fundamental rights. And then you have under the fundamental right, the enforcement procedure rules. Part of the principles is that provisions, international provisions on human rights or instruments or laws or cases can be cited to a court. So no employer should be under the illusion that, well, because NDPR is not, what is not in NDPR is not available for the benefits of an employee. That is not correct. So we can decipher the FHR 2009 rules relating to NDPR and ILO code. We can decipher the place of ILO code and the GDPR in our jurisprudence by looking at the mindset of our jurists. According to His Lordship, Honorable Justice Abdul Aboki, paragraph 3B of the preamble of the enforcement rule provides for the purpose of advancing, but never for the purpose of restricting an applicant's rights, courts with jurisdiction over human rights cases shall respect municipal, regional, and international Bill of Rights. I recall when we were working on the reform, we had this particular preamble in mind under the enforcement rules, so that at least if the final work is not as extensive, of course, it cannot cover all the fee, but we made sure that there is something in it that can enable, data subjects to import municipal, regional, and international Bill of Rights, such as the ILO code. But of course, we must say that the ILO code is not binding on its own. It's not binding on its own, but with the combined effect of the NDPR, the GDPR, and the enforcement rules, as well as the Constitution, Section 37 particularly, I think, then, of course, the ILO code becomes sort of binding. It constitutes a frame of reference for the enforcement of privacy rights. Now, something that we mentioned earlier is consent. And we said that consent is fundamental. Why? Because it varies the application, it varies the type of protection that a data subject has. So as an employee of an organization, it is assumed or presumed that you have given consent. You have given consent to the processing of your data. So consent of data subjects means any freely given, specific, informed, and unambiguous indication of data subjects wishes by which he or she, through a statement or a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. I hope that that is clear enough. But what this is saying is that consent is critical. And once you have given your consent, of course, it enables the data controller, which could be the employee now, or the data processor, the person processing on behalf of the data controller or the employer. It has given them the right to deal in your data, but subject to the principles earlier mentioned. So we have mentioned what the principles are. So in the application of consent, we have to be guided by the principles. So, however, under Article 2.3 of the NDPR, there are caveats, there is a proviso that no data shall be obtained except the specific purpose of collection is made known to the data subject. Data controller is under obligation to ensure that consent of a data subject has been obtained without fraud, coercion, or undue influence. Accordingly, where processing is based on consent, the controller shall be able to demonstrate that the data subject has consented to the processing of our personal data and legal capacity to give consent. Now, we look at the issue of legal capacity because a lot of people are in the place of employment. Perhaps they are under some form of legal disability, or that, well, maybe they don't have the capacity to give the consent, or they are not even literate enough to be able to understand what they are giving consent to. All these are captured under, the NDPR. Now, under Article 2.5 or 2.4, we are still talking of consent. No consent shall be sought, given, or accepted in any circumstance that may engender direct or indirect propagation of atrocities, hate, child rights, violation, criminal acts, and antisocial conduct. Now, if your employer or an employer is asking questions about about children and all that, which ordinarily should not be a part of the kind of data to be collected, no consent can be given in that. It should be given or accepted, even if you have volunteered it. It shouldn't be given. It shouldn't be accepted, and it should not be processed for any reason whatsoever. And this is a provision that is we can say that is a step beyond the provisions of the GDPR. Why? Because we looked at our own scenario and we recognize that in Nigeria, our level of literacy may not be as high as those of the or that of the European Union jurisdiction. So we looked at a situation where people can take advantage of who we are or what we are, and then begin to process data because we are freely given our data, our personal data. The controller rights of a data subject applicable to employees. Now, we have stated that the NDPR makes no distinction whatsoever between amongst classes of data subjects. All data subjects, whether they are employed or they are not employed, they all have equal rights. What can limit the application of NDPR, as we have stated earlier, is the issue of consent. So we always, in any agreement of privacy policy between employer or in any scenario, we take the issue of consent very seriously. So, be that as it may, we have the rights of data subjects. The controller shall take appropriate measures to provide any information relating to processing the data. What is central to this, so that we don't waste so much time, is the fact that data subjects have rights. Critically, information, transparency, just those principles. Those are the things further explained under the rights, or and how to go about those rights. Now, for instance, there is a right that you want your data to be taken to a particular place. Portability, that is part of your right. You want your data to be erased. That's the right to be forgotten under the NDPR. You were once employed in that place, and then you just felt for one reason you don't want anything anymore to do with this particular organization. Then the best the organization can do is to, maybe for security reasons, properly archive your data, but you have a right to be forgotten. Not that after leaving the place, you are still getting messages of work schedule, maybe unintended, or you are still getting some notices that suggest you are still one way or the other connected. Maybe not as an employee, but as part, or maybe as a visitor of your former place of employment. Your right to be forgotten has been infringed upon if you get such things. Part of it again is stated that, except as otherwise provided by any public policy or regulation, information provided to data subjects and any communication. We are looking at 2.13 now, where except as otherwise provided by any public policy or regulation, information provided to data subjects and any communication and any actions taken shall be provided free of charge. So you don't go to the employee does not, or the employer does not say that, look, you have to provide money, you have to do this before we can, process your data. A lot of organizations tend to do that, but by no means, or that an employee must perform certain things before such can be released to you. That will not be allowed. Where requests from a data subject are manifestly unfounded or excessive, in particular because of their repetitive character, the controller may either charge a reasonable fee, taking into account the administrative costs and all that. These ones are self-explicit. Now, prior to collecting 2.13.6, prior to collecting personal data from a data subject, the controller shall provide the data subject with all the following information: the identity and the contact details of the data controller, the contract details of data protection officer, the purpose of the processing for which the personal data are intended, as well as the legal basis for the processing, the legitimate interest pursued by the controller or by a third party, the recipients of categories and recipients of personal data. Now, I think all this are clear, but there is a gray area here, which is the issue of legitimate interest. Whose legitimate interest at the implementation roundtable we had on NDPR, that is after passing the NDPR, then the issue of legitimate interest comes in, and that data can be processed subjects based on legitimate interest. So, for instance, your employer can say that I'm processing this data because I have legitimate interest to do so. But under the law, the legitimate interest is not the legitimate interest of that of the employer. It is the legitimate interest of the law of the state, not any other legitimate interest of that which has been mutually agreed upon without fraud between the data subject, that is in this case the employee, and then the employer, who is the data controller. I want to believe that we are familiar with the terms such as the data controllers and data processors. For the purpose of our discussion, we will take the employer itself as the data controller. Then data processors are the third parties. For instance, MTN wants to recruit. MTN is the data controller. Then it has engaged KPMG to process recruitment process. For that purpose, KPMG can perform a dual purpose if it's sourcing the data directly, or it got the data of potential employees from MTN. For that, it will just be a data processor. But if it got the yes, of course, if it got the data from MTN, then it's a data processor. So when you see data controller or data processor, they are under, notwithstanding, they are all under the same obligation under the NDPR. I think.
Quick question for you on the data protection, on the.
Hello, hold on. Hello, can you hear me?
Yes, I can hear you, Babatunde. So
right.
Quick question for you on this issue of data processes and legitimate claims. What happens where, and in the context of a medical research, where we had obtained consent to commence the research, but along the line, the focus of the research has expanded, and we are looking to use the medical samples we already have for what we can call further processing. How will that work in practice? Now, in the consent that the patients had given, it was limited to particular circumstances. But here we want to expand the scope of what we're going to use that data sample for. And is there a way we can do that without having to go back to the patients? And if there's going to be a subcontracting really of the processing, whose obligation is it to get the consent, to get further consent if it's required at all?
Well, for the purpose of a particular research, data processing is limited. You cannot go beyond that particular purpose. Further processing must not, for instance, if let's just situate it properly. If an employee consents that maybe in a pharmaceutical company, a volunteer that you take my phlegm or what have you for to determine how to, have or develop a cough syrup. And then in the process of doing that, the company realizes that it can also, through that swab or whatever you have given, they can also determine or do further research on fertility. Are you with me?
Yes.
Hello? You can see that this is absolutely very far from the initial purpose. So what you can do is, if the initial consent is given for medical purposes, that means for pharmaceutical purposes or for whatever purposes under health, then you can go. Then it may be that at the time, this is where you can be covered, that at the time you are given the consent, it may actually be for, to develop cough syrup or potent antibiotics for cough. Then, because it is generally for medical purposes, you are now doing further processing. Hello?
I'm here. So does it not matter that the further processing we're conducting is still for medical purposes?
No, because the consent given was not a broad consent. Because the consent, that is why you have the principles. Consent must be given subject to principles of the NDPR or GDPR. It must be given subject to principles. And the principle, the fundamental principle is purpose limitation. What is that purpose? To process for your medical records, to study your medical record and process only for the purpose of developing antibiotics. Then now you are using it. You have gone beyond that specific purpose already stated. Are you with me? You are going beyond the purpose already stated. Then you are doing further processing. The intendment had to be, the consent had to be as broad as possible. That is why when you go to sites, websites, you will see data privacy policy or privacy policy generally couched in some ambiguous words that the cookie, these websites, just like they say, is use cookies to determine your preferences and all that, and so that they can optimize the user experience. This is a very vague, ambiguous, broad privacy policy that ordinarily should not fly in an environment such as ours. But because the way the consent is given, it is broad. So further processing beyond what you think you are doing, beyond you have gone to the site of, let's say, Punch newspaper, and then your belief is that any data processing on the site of Punch newspaper is for the purpose of delivering better news to you, maybe political opinion and all that. But because the way the privacy policy on the sites of Punch newspaper is being couched, it may also mean that the Punch newspaper, which is the data controller, can allow third parties to post, to tailor content, to post adverts, to project adverts of pornographic sites if they have such parties, or for alcoholic drinks, or for any other purpose whatsoever that they are in partnership with. It allows them to be able to project it to you. So that is why sometimes you find things on your Facebook page or your Google account, AdSense, or any website. You just find things that you wonder, how is this related to you in any way? But if the sites that you had visited, they process your data limited to the very thing that you are looking for on that site. I'm on Punch newspaper, I only read maybe business news. So if I'm going to get anything at all, it should be about business, not about religion or some other things that are unrelated to what I am on that site for. So consent, just like we said, consent is very critical, is the gray area. And then by reason of the NDPR, we have provisions now prohibiting certain aspects of data processing, such as malicious, when the motive is malicious, because at that stage, even if the consent, an employee or anybody can give his consent, we agree. So we don't want to do anything that will further breach the privacy rights we are trying to protect. But we now realize that now at your private level, you can consent to anything. But whatever you do, don't do anything that will compromise national security by maybe you consent and then certain videos, propagation of hate speech and all that can be shared through you and all that will not be allowed. So that consent is restricted in a way.
Thank you.
Yeah, you're welcome. So can we go further? Hello.
Sure, continue.
Now, there is what you call neither mechanism for redress of digital rights. Now, part of what we discovered is that all this issue of rights here and there, employees may not be able to go to court immediately to file claims because even the EU, some other rights, like the right to life, or so serious, scenarios of violation of human rights takes so long. And these are things that affect what you call the adequacy level of a country. The inability of a country to provide remedy. The inability of a country to provide remedy affects the adequacy level of that country under the NDPR, and also the inability of an organization to provide remedy in the events of breach also limits the corporate governance outlook of that company as well. So we looked at it that it is good for NIDA now to have a mechanism where it can redress digital rights. So before even going to court at all, you can approach NIDA, and then NIDA can give the remedy you require in a limited degree. It may not be able to award damages, but of course, where an organization or an employee finds that, look, my data is being processed unfairly, and we can even say that at what point can an employee go to court? By reason of the fundamental rights rules, you realize that threats to rights to privacy in itself constitutes a cause of action under the fundamental rights. So also, where an employee sees that there is likelihood of threats, likelihood of violation, that is, of his rights to privacy, especially where that organization has no privacy policy. Anybody just can access the HR and then get documents anyhow, or the HR manager just leave confidential information anywhere, or that for just name all such scenario. Or you look at the system being used. Maybe they have your data online, the way they pay you through online medium and all that, or they have your data online, and then the website is not good enough, not secure. Then the employee can approach NIDA directly. Say, look, my employers are processing data this way, and that constitutes a threat and a cause of action immediately. So if any organization now has no privacy policy in place, they are already breaching the rights of their employees, simpliciter. As of today, if there is no privacy policy in accordance with the NDPR, right? And I think that is even the major catch of this discussion. If you don't have privacy policy in place for your employees in accordance or to the standard of NDPR, then at that level, you're already in breach of the NDPR.
Sunday, I hate to butt in here, but our time is up. We have just about 5 minutes for you to round up, because I know there are lots of people who have questions for you, so we don't keep people going for much longer. So if you could quickly wrap up in 5 minutes so we can take questions.
We can wrap up in 5 minutes. So the last part of it, of course, is the ILO collection of employees' data. And this is a take-home, I think, for all employment lawyers and labor lawyers in the house. You look at Article 6 of the code. It says all personal data should, in principle, be obtained from the individual worker, not through anybody. That is, if it is necessary to collect personal data from third parties, the worker should be informed in advance and give explicit consent. For instance, the right reference to so place, tell us about this individual. The employer should indicate the purpose of the processing, the sources that and means the employer intends to use, as well as the type of data to be gathered. Now we can look at all this at our, at our private moments and import them for the benefit of the employers, or for the benefit of the employees. Now, I think another thing is under the under the ILO principles, is drug testing to be undertaken only in conformity with code of practice in management of a alcohol and drug-related issues. So your employer shouldn't just harass an employee anyhow on the reason of whether he's taking alcohol or not and his activities. If taking alcohol is not the basis of his employment, then all those all those things that tend to invade into his privacy or his lifestyle, if it doesn't affect his job, should actually be avoided. So basically, that is what we have.
Thank you so very much, Babatunde. Absolutely timely and very informative. And I'm sure I have lots of questions for you. So I'll open lines. To make this easier, if you could just type your questions in the chat box and I can read it out so that it's a more seamless process.
I would love to ask my question.
Jami, is that you?
Laolu, my name is Laolu, sorry.
Okay, Laolu, okay.
Can I ask?
Post your question. It might be easier.
Oh, because I'm also working. Oh, okay. Let others, maybe they might ask the same question.
You're working?
Yeah, I'm still working. So I'm just using multitasking. It's fine. Let others ask. They might ask the same question.
Go ahead, ask your question.
Well, I'll defer to the speaker, then Laolu, so ask your question.
Okay. Thank you for the indulgence. I'm going to start with the last thing you said about monitoring and routine testing. So life case, I believe I can share this without. So let's say at this company company had this issue recently. So that's how I'm going to mask it. They have this employee that suddenly disappeared for days. And by the time he was found, the police had to trace him. I think after some weeks when he wasn't found, the company reported to the police, and then they started tracking him, and eventually they found him, and it was discovered that he had an episode of mental illness and had relapsed. Now, at work, company A's clinic sort of has an idea that he has an issue with mental illness, but his department, so to speak, doesn't know about this because of reasons of privacy. Now that it has come to the fore that he's had this relapse and all of that, and sometimes he has relapses that people around him don't seem to know or are aware of, only the medical people know. This issue of privacy and all of that, to what extent can they now take on that responsibility? Because when it did come for advice, one of the concerns we had was, aren't we doing too much already trying to manage the situation for him? And then with regards to this issue of GDPR and all these privacy issues, concerns especially, we will not be doing so much if we have to keep, because one of the things that was suggested was, let his unit head or his departmental head constantly remind him of the need to be in the hospital to ensure that he doesn't fall back into a relapse and all of that, since he spends most of his time at work. To what extent are we not going to jump into that divide that we ordinarily aren't supposed to cross? And knowing fully well that if you decide to just lay this person off, it might look like, although you can do that, it might look like that's the reason why you are doing it, because of what has just happened recently. I hope my question is clear.
Your question is pertaining to him, that can the employers handle his can they manage his medical,
Yes.
health issues?
Yes, without overstepping their boundaries.
Yeah, what we said is that consent is critical. In a way, if he submits himself to that process, he has consented to it already. And of course, you are doing it. You have to have regard to your employment contract. You must have regard to what the employment contract says, as at the time he was in his right frame of mind. why he gave consent, so that you won't have problem if he comes around and say, look, you guys knew that I wasn't actually in my my right senses. How come you were doing this, you were doing that at that point in time? So if you are not the next of kin, and that means at the initial stage he had given a consent, freely given. At this stage, because of his mental condition, it cannot be said that he has given consent. Are you with me?
I am with you, absolutely, sir.
Your initial agreement, the initial agreement stands. Anything you are doing outside that agreement is at your own risk.
Wow.
At your own risk, unless, of course, you have the next of kin coming in, engaging you. So you are now relying on the legal capacity of that person to engage you. The current person has no legal capacity.
Precisely.
Yeah, and you'll see under the issue of consent as well, we looked at legal capacity. So it has to be determined as well in his favor whether he had legal capacity to give consent for you to go ahead and do the things that you are doing.
Thank you very much.
Yeah, to be a problem.
Thank you very much. We'll work with that next of kin option. Thank you. I appreciate it. Thank you so much for the indulgence.
Thank you. You're welcome, sir. Any other question?
Okay, I have a question. My name is Jeremy Akolade. Thank you for the presentation. Two questions. The first one is simple. Does a phone number qualify as personal information? And what is the implication for someone who shares a friend or colleague's phone number who he happens to have in his contact list to another person just by the asking? Is there any kind of consent required? Then my second question is, you mentioned something about certain personal information outside of the scope of what an employer should be interested in. I don't know if I got it that way. So for instance, these normal forms that ask for the employee's religion, are you saying it is unlawful for us to ask such a question? So what is the limit of questions that employers can ask from their employees? Those are my questions. Thank you.
Very good. The first one, we have to understand that strictly speaking, NDPR applies to organizations processing data. It applies to organizations processing data. And that is why we call them data controllers and data, data processors. So now, if a friend asks you for the personal data of, that is the phone number now specifically, it asks for the phone number specifically, and you shared it on a private platform, to that extent, as a private individual, you are not liable under the NDPR. We have to understand the subjects and the objects of NDPR, just like international law. Under the international law, you have the subjects of international law and the objects of international law. So private persons are not really subjects of the NDPR. They are objects of the NDPR, although we regard them as data subjects, but they are the objects of the NDPR in the sense that they don't come in to file processes and all that, just like private persons don't go to CAC to file annual returns and all that. So a private person can hardly be liable. But of course, if a private person now is sharing that message as the MD, I'm sharing the information, let's say Zenith Bank MD is sharing the information of a customer who is his friend on a platform. you know, on another platform openly, and I'm sharing it with you, or maybe it can be imputed that, okay, I'm sharing it with you as the MD of Zenith Bank. So he's sharing it as Zenith. Are you with me, sir? So the bottom line is, you can share phone number. However, again, motive is important, and that is that is where the NDP is. That is where the gray area of NDPR comes in. Let's take the issue of our WhatsApp groups, for instance. WhatsApp group is a data processing platform. It's a data processing platform. Now, when you share phone number on that platform, you may be regarded, although this is almost like an hypothetical case, you may be regarded as being constituted into a data controller or a data processor for the purpose of NDPR. Why? Because the platform upon which you are using it is a big data platform that you could be liable for. And do not forget that it is not only NDPR that regulates privacy. It's only that it's NDPR that is regulating the issue of data controllers and data processors, big data. But you have other laws. You have the ECOWAS Supplementary Acts on Data Protection. You have the Cyber Crimes Act. You have all this. Then you have the privacy rights, the fundamental rights on privacy in itself. So even if by any means you escape NDPR, you may be liable under the Cyber Crimes Act or the ECOWAS protection. And NDPR, what NDPR now allows a person to do is to be able to import those other provisions of law in application. So that is where the NDPR can come in aid of anybody whose phone number has been shared. Now, the scope of, am I clear on that, sir? Hello?
Very well, sir. Very clear.
Right.
Thank you.
Oh, thank you, sir. Now, scope of information. Now, in a country like Nigeria, are you with me? Hello?
I'm with you, sir. I'm with you, sir.
In a country like Nigeria, you have the federal character. And what's the federal character? We are multilingual, multi-religious, multi-everything. For that reason, for the purposes of employment, in a government environment, you may need to ask the religion so that you don't have the predominance of religion or this thing. Then about sex, of course, there are countries, even in the UK, on some EU jurisdictions now, you have to have what you call affirmative action. How many blacks are in your employment? How many women are there? So you need to ask all these questions, whether it is necessary. But what you cannot do is the issue of sexual orientation, your preferences in terms of marriage, whether you are open to polygamous or not. All those things are questions that should not be asked in employment scenario in Nigeria. There are the issue of maybe your background. Generally, those things that are not under maybe the fundamental objectives and directive principles of state policy. it has no legitimate interest that it seeks. Maybe the way the questions are asked, they are even asked to embarrass or to disqualify a candidate. I recalled as a time I wanted to read law before coming to OAU, and it was in UNAD. We were going from 200 to 300 level, and they said no mass, no law, in 99 or so. And then we took the matter to court, and the judge, the school said that the school said that the school can disqualify a candidate just for any reason. And the judge asked, Justice Sakeju is now the Court of Appeal. He asked the question, do you mean that? So if I get to the last stage and you are asking me that you are too dark, what is your complexion? And for that reason, you are being disqualified. You know, he said, this is Court of Justice and will not allow you to just ask any question. So you will know the kind of questions that ask little reason with the kind of employment you are embarking upon. But somebody going in for a beauty pageant, or you want to be a model, where your skin color, your shape, everything has to do with, relates to marketing. Some questions are allowed. But outside such places, come and ask me what the size of, you're asking lady, her body frame and all that. Those are not legitimate questions. Or you are asking a question, are you on diet, or you doing diet? These are questions that imply whether you are trying to look whether the person is trying to trim down, or you want to see whether the stature, maybe you don't like it. Then you're already asking a question along that line. These are questions that should never be asked.
Thank you, sir. Very clear.
Thank you very much.
And so we have a question here. To what extent can a data controller continue to retain personal data after the demise of the data subject? Can the estate of diseased data subject exercise any right against the data controller?
Perfectly. Data is, of course, we know that data is a right, and the right, that right, a fundamental right, we understand in law, dies with the person. However, data in a data economy is an asset. Are you with me? Data in a data economy is an asset. So not just a right, it's a property. So it's just like an estate now of a deceased person. Even though his personal right dies with him, but as much as we see privacy right as a personal right, we also see it as a proprietary right, your personal information. So to that extent, the estate administrators, the trustees or what have you, can come after this thing. Then you can only keep for security purposes. You can only keep for security purposes. If you are still maintaining the person as a ghost worker, for the purpose of collecting, you know that data processing is unlawful, even to that extent. So it's the estate can come after you and tell the employer that, look, you can no longer use the personal data of this person, or his picture is still being displayed in a way that suggests that he is still a member of that organization. Maybe he's still on the website as a partner. That is not appropriate. That is not appropriate.
Thank you very much, Babatunde. And that's all we can take on this session for today. Thank you so very much to everybody who dialed in. If you have any further questions, you can still send it to us and we'll pass it on to Babatunde privately, and we'll come back to you if you leave your contact details so we can come back to you. We're very grateful for everybody who made time to join this, and especially to Babatunde, who agreed at very short notice to take this session. Thank you all for your time, and we'll see you same time next month when we have our webinar for March. Thank you all.
Thank you.
Thank you very much for having me.
Thank you. Thank you, guys. Have a good one.
Thank you. Great presentation.
Thank you.
Thank you very much. Thank you. I appreciate it.
You didn't ask to. No, no. I wasn't listening to it so well. I listened to the